Haan, that's Boaglio v. Boaglio. We have Mr. Sandy. I was thinking we had Mr. Boaglio. I thought I admitted him.
Here, Your Honor.
Okay. All right. An attorney has just now been appointed to represent you in the contempt matter. So this matter really can't go forward today. And with you don't have your attorney here and you haven't met with him because it was just occurred. His name is Tom Lee, L-E-E, is going to be your attorney. And so what I'm going to do, Mr. Boaglio, is set this over to April 23 at 9 a.m.
Okay, can I clarify something really quick? I got a call from Savannah Williams, I thought was going to be the attorney.
Well, maybe I'm confusing that. I thought it was on your matter.
Maybe I misunderstood and she could be a legal aid, but I thought she was going to be here this morning or spoke with Mr. Zandy.
Maybe I confused that. Miss Williams, are you on?
Yeah.
I'm sorry, you broke up there a bit.
And that's who I've been communicating with too, is
Okay.
Miss Williams, Judge.
I apologize, Mr. Boaglio. We've had 3 or 4 of these, and so it's that's confusion on my part. I thought the order I just signed was in your case, so apologize for that. So, Miss Williams, the idea is to set this over to April 23 to give you an opportunity to meet with your client and be prepared on this matter.
Litigation against one's interest is paramount to ensure the parties receive process and an opportunity to contest claims brought.
I don't know what that was, but it probably needs to be muted.
Apologize, Judge. That was my Waukegan County docket.
Oh, okay.
I've turned that off. I'm here now.
Okay. All right. Ms. Williams, are you on here? I don't see the name. So, Mr. Boaglio, bottom line, I'm going to set this matter over to April 23 and not do anything on it today. Okay.
Thank you.
Jackson and Jackson matter. All right, this is a like scenario. An attorney has just been located and appointed to represent you, Mr. Jackson, in the contempt matter, which is what this matter is on for. He has a right to an attorney, so this matter will not be going forward today. The attorney is just coming on board. And so I'm going to set the matter over to May 7th at 9 a.m. Has just been located and appointed to represent you, Mr. Jackson, in the contempt matter, which is what this matter is on for. He has a right to an attorney, so this matter will not be going forward today. The attorney is just coming on board. And so I'm going to set the matter over to May 7th at 9 a.m.
Yes. So we're doing a scan today with IV contrast.
You need to mute your connection, whoever that is, please.
You had originally set it for May 23rd. I mean, April 23rd. So that's no longer going to happen.
That was a different case. This matter I'm setting to May 7th.
Okay. And the attorney name is?
You can call court administration. I don't want to make a mistake because there were 3 different attorneys that were appointed.
Okay.
Okay. All right. Call court administration. You get that name.
May I have a question, Your Honor? Because for today's hearing, we had the temporary spousal support modification.
That's what I thought.
I'm not going to address that matter here today. We're going to set everything over to May 7th.
So including the contempt?
Correct.
Okay.
Okay.
Okay. 08 Yanis and Yanis matter. That's Ms. Baldwin and Ryan Yanis.
That matter's ready. Mr. Yanis is present, as is the guardian ad litem. Guardian ad litem has filed her report timely in this manner. We're just under review to make sure that that report has been filed. It has been filed. Report is generally what the parties are currently doing. So at this time, I don't think there's anything that the court needs to do.
Okay, Mr. Yanis, anything from you?
No, I'm good.
Okay. All right, with that, that takes, and we do have Ms. Turnbull. Anything from you?
No, I think my report summarizes my position.
Okay. All right, so with that, nothing further. That takes care of that matter.
Thank you.
And Acevedo? Just a moment. I see Mr. Anagnostou. And I see Ms. Corey is online. And do we have Ms. Acevedo?
I'm here, Your Honor.
All right, thank you. All right, this comes on for a request for a restraining order. And I want to note a couple of things. One, I had an order that had been signed off by both parties. I signed that this morning and that's in for filing. And then this is on for the restraining order here. I did receive the sealed personal healthcare records. And I just want to make sure that Ms. Acevedo received those as well.
I did.
Okay. All right. So with that, Mr. Anagnostou?
Yes, Your Honor. This is my client's request to basically suspend visitation and have the guardian ad litem look into these injuries with the children. If we're going to allow visitation, it should be day visits only. The children are coming home with cuts and bruises and injuries on a repeated basis. My client has submitted the medical records. The doctors looked in it, and yeah, they have bruises and cuts coming back from Miss Acevedo's house. So the children are being harmed, and we're asking for some protection on behalf of the children. While these matters are looked into, my client has reported this to Child Protective Services and is doing everything he can to protect the children. But the visitation is what it is, and he's still complying with the court's order, sending the children, and they continue to come back with injuries.
Ms. Acevedo?
Yes, Your Honor. A lot of the injuries are coming from Mr. Crocker's house. I have been taking pictures of the children, usually before they leave my home and when they return with the states that they're in. Some bruises and cuts can be hard to see in the black and white photos. So I have to find a way to get those photos to you in color so that you can see them. But most often I do take photos of the children before and after they leave my home. And they're nothing more than standard toddler bruises. They're crazy wild toddlers. They fall down. It's bruises on the shins. The only significant injury that one of them had was falling into a metal kennel, in which we notified Chris what had happened. I actually wasn't standing there when it happened. There was the other kids present. And then some of the concerns that Mr. Crocker is talking about are burns on Callie, and they aren't burns. They're hematomas she's had since birth. I watched them grow on her as she was in the NICU. So there's confusion there. And I did submit yesterday notes from the doctor. I took the children to their primary care doctor, and she noted that there was no bruises or cause for concern whatsoever. And in Mr. Crocker's submitted forms from Legacy Health, they also didn't seem very concerned about abuse as well. They were just noting Chris's concerns.
Corey, have you received a copy of the records?
I have seen the records that have been filed with the court, yes.
Okay. Any input at this time?
So I would, because it's an open investigation, CPS won't talk to me about this just yet. I expect that to be concluded fairly quickly. And I do have a concern that a person whose child was taken by CPS is reported to be living currently with Mr. Crocker. But that's really the extent of my knowledge of this right now.
Mr. Anagnostou?
Ms. Acevedo filed documents late yesterday. I haven't had a chance to even review them with my client, but it sounds like an admission to me that Ms. Acevedo says there are active kids, they run around, they get injured, Well, that doesn't happen at my client's home. That's just not happening. And he's diligently trying to protect the children and need court's intervention at this point to protect the children.
So one of my questions, Mr. Anagnostou, is have you had contact with DCYF?
I have not.
Okay. I'm just wondering if we know how much time they anticipate they'll take with their investigation.
I could potentially find that out. Generally, they won't talk to you about an investigation until they've completed it.
Yeah, I'm looking more for the timing than anything.
Right. I might be able to find that information out.
Okay. So I did not receive mom's records. So I did not see those, just so you know that. I think what I'm going to do at this time, I am concerned. The pictures do show the bruising. It takes a specialist to tell me whether or not those are bruisings from just a simple fall, or whether or not those are bruising from something more significant, such as child abuse. So that doesn't really show up in the emergency room records. It talks about what father reports, but I don't have anything more. My concern is DCYF is having the investigation going on. So I think what I'm going to do at this time, we're a little bit short on I'll go ahead and add this to April 23 in hopes that maybe DCYF will continue. I do want mom to have some visitation. I don't want just an absolute restraining order. And what I want is supervised visits, at least for now. Is there somebody that at least for now can do some supervising?
I would recommend Miss Acevedo's father.
All right, Ms. Acevedo, does that work for you?
Unfortunately, my father is in the military and he is doing Army training and will not be in town until June.
Okay, no, that's not going to work. Any other thoughts of who in your family might be somebody?
Unfortunately, no, my cousin just moved to Kansas this morning, so I do not have anybody on my side of the family, but I am in agreement with Mr. Crocker's father being somebody that could supervise.
Mr. Anagnostou, would that be something that would be available?
I don't know. I would need to ask my client and talk with his father to see if he'd be available. What kind of visitation are we talking about?
So unfortunately, without knowing his schedule, is he retired? Does he work or?
He's a bus driver for the Kelso School District. I believe he works early in the morning until roughly 11 o'clock, maybe in the afternoon, and then he returns back to drive the bus, other than on Wednesdays, somewhere between 1 and 5, I believe.
Okay, and Ms. Acevedo, are you working now? Do you?
No, not currently. I am actually got quite a bit of job interviews. I'm trying to move into a new town soon, so I'm trying to find new jobs up north. So I'm usually not in Longview. Okay.
Well, at this point, what I'm thinking about is it's a little bit limited. And we're not talking about a whole lot of time here, meaning I'm looking to set this over to the 23rd. But in the meantime, I do want some visitation, some day visits on Saturdays from, say, 10 to 5. And then on Wednesdays, something that can be worked out where, again, maybe something that works with his father.
His father, the schools get out early on Wednesdays, so Wednesday might not work. Thursday might be a better day for his father.
Okay. Well, let's start with Wednesday just because I want to make sure it's kind of broken up a little bit, but I'm thinking on Wednesday, something like 3 to 7, 4 hours on Wednesdays. If Wednesdays don't work, Thursdays is fine.
Okay, I will reach out to him and we'll set
Right.
something out.
So a 10 to 5 p.m. visit on a weekend, it could be a Saturday or a Sunday, and a 3 to 7 roughly p.m. Visit on during the week someday.
Correct.
Okay. I can work out the details. We'll find somebody to supervise.
Okay. And then, like I said, I'm going to set this back on for the 23rd. By then I should be able to see mom's records that she has. Hopefully DCYF will have some information. Maybe the guardian ad litem will be able to get some information by then. Hard to say, but we'll see.
And then, so for the
Your Honor,
visitations,
Hold on, Ms. Acevedo. Go ahead, Ms.
would I be reappointed on this case then, since I have completed my report?
I would reappoint you. Yes, under the same terms. All right. That's what we'll do for now. Set the matter over to the 23rd and go from there.
Thank you, Your Honor.
All right. 13 and 14, Ms. Winkles, are you here yet?
I am, Your Honor. I'll probably have to jump back over, but I believe we did not get served, but I believe Mr. Crippen is asking for continuance if he's here.
Okay. So I'm not quite sure how to say the name, Harsager and Crippen. No response from the respondent, Mr. Crippen. Mr. Crippen, you're requesting a continuance, is that correct?
That's correct, Your Honor.
Okay. Any objections, Ms. Winkles?
My only objection is not on the CIR, but on the return of property. This has been held. He doesn't make any claims in his continuance that it's not his property. It's clearly my client's property that was left at the residence. We would ask that my client be allowed to pick up those items. A lot of them have been essentially told to my client that they're going to be thrown away. That's not appropriate here. We have a lot of expensive items there. So I'd ask that my client, in the meantime, in the next 2 weeks, my client be allowed with a civil standby to go and collect all of her items and to remove them. And then the rest of the case, the CIR, we can continue that and do it normally.
Mr. Crippen, any objections to that?
Your Honor, no objection. She's already picked up 70% of this by the end of January, early February, starting in December. And I've been begging her to go ahead and get the stuff off there. I've been helping get the stuff off there at my own expense. My son's been there. My son-in-law has been there, taking out U-Haul trucks. And while she's been in communication with them. So the sooner this gets done, the property, the happier I'd be. I'm not trying to hold the property. I don't want nothing there. It's cluttering up my property.
Sounds like no objections. So Ms. Winkles, that'll be granted. And then let's go ahead and set this over to May 7th. That's the next available docket.
Sounds good. Thank you, Your Honor.
All right. That's it for today. Airhorn and Worrell.
Thank you.
Hopefully I'm saying those correctly.
Matter's ready, Judge.
It'll be just a second here. All right, so I see Mr. Zandy is present. Do we have Lake and Airhorn present?
Present, Your Honor. Yes.
All right. All right, go ahead.
And thank you, Your Honors. Court's aware I do represent the moving party, the original respondent, Daniel Worrell. Here on my client's motion for temporary orders as it pertains to the party's 5-year-old child, Declan. You've got our pleadings. You can see where there is very significant changes since these parties were last before you back in 2022. This is a case that's just kind of been dying on the vine since the temporary orders were entered on that. My client kind of details for you what his mindset was at that point in time. Tells you that his approach to things at that point was somewhat dilatory and shameful, and he certainly regrets that. However, here we are, and he has done everything that the court has required of him, and then some. He's taken his evaluations, he's complied with treatment, he's taken a hair follicle test in an abundance of caution. He's done essentially everything that was required of him, plus more. So that's kind of the starting off point. As far as changes in circumstance, even though it's not necessarily required because we're still on temporary orders years later, there's been several. My client, in addition to the work he's done to better his situation, there's been a negative effect for the mother. We've given you police reports, and there's several. We've given you the charging documents. We've given you information related to witnesses that have come forward and been somewhat candid in their approach and concern with what's going on at mom's house and basically the effect on Declan. I'll start with the easy one, and that's it looks like the month of July was not good at all for mom. The effect and impact on the child is obvious, as every police report we've submitted to you shows that Declan was present during mom's arrests and mom's levels of intoxication. The police report from Castle Rock July 15th is especially concerning. It shows that mom, and I don't know how far the court went in reviewing that. There's the officer's report. There's also the catalog that shows the 911 call that shows mom was not only intoxicated, but she was nearly 4 times the level. There is witnesses calling in erratic driving in which she almost rear-ends somebody. She almost runs over a mailbox. She is outside her mind, impaired, gets pulled over in front of the Oasis Tavern in Castle Rock. And as the police reports indicate for you, it was obvious when she rolled down her window that she was drunk. She admits to such. When the police finally were able to get her BAC reading, again, the level of intoxication is extreme. The first was 0.336, the second 0.331. That's nearly 4 times the legal amount. And meanwhile, 4-year-old at the time, Declan, is in the back seat, not only subject to mom's driving, which shows a complete lack of ability to consider the child's best interest and safety, but is also there when the police arrest her, take her in, and he's left with 2 sheriff's officers waiting for other family to come pick him up. So again, looking at that from a 4-year-old's perspective, that's not only scary and life-threatening, but it also creates an emotional level that frankly should have completely been avoided. If you look at the other information, and 2 weeks prior to this in Clark County, my client finds out that mom has an active protection order against her, protecting an individual named Nigel Adams, in which she violates that. And again, the child is present for that. Clark County gets a call that there is a restraining order violation in progress, only to arrive find Mr. Adams in one section of the freeway, mom some 50 yards away, and a child, again, 4-year-old Declan, who is on the side of the road where there is a high volume of traffic going by, to which the police officer notes specifically in his report that he had to go and take the child to make sure that he was safe while mom is just sitting some distance away. She's charged with violating the protection order. In September of 2023, same parties, Miss Airhorn and this Nigel Adams, in mom decides in Cowles County that she's going to file a protection order against this individual. What she cites, again, is concerning. In February of 2023, and I'm reading directly from her petition, respondent suicide by taking pills while my 4-year-old son and myself were home. The attempt required medical intervention and mental evaluation. She goes on to claim that he has mental instability and multiple suicide attempts. The current concern from this is not only does she already have a restraining order out against her from the same individual, but she cites repeatedly, and this is going back to February of 2023, prior to the incident in July, that the child is readily subjected to this person and exposed to this person. So again, what is the priority from mom's perspective? It appears throughout the last several months, it's getting loaded on alcohol and it's exposing the child to people that child should not be exposed to. Moving forward, and this again is more recent. She now exposes the child to another new romantic partner. Now, we understand that they're still together, although we don't have confirmation on that. And we know very little of this person. If you look at my client's declaration, it's complete with not only the obvious concerns, which are those I just mentioned, but also the concerns about what this child is preparing for now that he's 5. Now, he's of that kindergarten age, but my client details for you, this child is nowhere near ready for kindergarten. Now, this is a child who goes to dad's house and cries that he does not want to go back to mom's. This is a child who has immense fear and pressure to the point of hysteria of getting his hair wet. He's afraid of water. And this is a child who has significant speech delays. This is a child who needs some exploration into what is going on at mom's house and what is causing a lot of these issues. And I think it's somewhat obvious. So we are asking for you to modify the parenting plan. Parties have done that largely on their own. My client reports that back in the summer, he was having a joint plan during all this chaos with Ms. Airhorn, in which he had the child a regular amount of time, only to the fall to come around, and mom says, well, I'm going to pull back on that. Instead of having a week on, week off, or near joint time, it's going to be Wednesday to Sunday are going to be your weekends. She now has tried to pull back on that further by saying, well, it's going to be Thursday to Sunday. Mom has been put in the saddle of this case where she is calling the shots. She's trying to do that. And I understand the court's concerns back prior to my involvement back in 21 and 22. But again, this has resulted in something where mom is now completely self-destruct mode, and mom is now exposing the child to these types of what I would only call volatile life decisions for her and the child's put at risk. We're in a different situation now in 2024. My client has done everything that's expected of him and then some. My client is with a long-term partner now. They have a child born as issue of their relationship. Declan loves being an older brother to that sibling. Life is good at my client's house. It's stable. My client is working a meaningful job at Weyerhaeuser where he continues to thrive and support his family. He's making the right decisions. And again, it's not often that we can say that. It's not often that we can see an individual who finally owns up to the shortcomings in his life and takes active steps to resolve those. And that's, probably what my client has done. So we are asking the court to consider modifying the parenting plan to a very large degree. We're asking the court to enter a joint plan, which is a week on, week off, pending some kind of a GAL investigation. I think that's certainly warranted given the circumstances. Amy Turnbull was the original GAL appointed to this case. She did very little. If the court wants to reappoint Ms. Turnbull, we're certainly agreeable to that. If the court wants to go fresh off the current registry, again, we're fine with that. But we've got significant concerns about what's going on in this young man's life, and the need for changes is certainly present, and we're asking the court to grant the relief as we've requested. As it pertains to child support, I did speak to Ms. Looney. She is currently on the docket in Wahkiakum County. This is a state-involved case. My suggestion, until she can provide input, and if the court is willing to adopt our relief as requested, that we just do that on the parenting plan, come back and revisit the child support in 2 or 3 weeks when we have the presentation date. I'm certainly agreeable to that. But time is of the essence, given the emergent nature of the circumstances of mom and child. I think our form of relief is appropriate. Again, pending some significant input from a GAL who I understand is going to have a lot to look through, and this is going to be a tall task. But nonetheless, given the circumstances as it finds the parties and this child, it's appropriate.
All right, Ms. Airhorn.
Yes, Your Honor. I was going to ask for some more time because the attorney that I originally was talking to, we had a misunderstanding, and I've called around everywhere in Cowlitz County, and they said that they're at capacity. I've had a legal person helping me, but after this, I have an appointment over at the Cowlitz Indian Tribe to help me with some legal stuff to get this all sorted out. But I did file declarations and a sealed document on my behalf for you to look over in the meantime, and I did reach out to Amy Turnbull to let her know I'm willing to proceed with her in any way. Whatever you said.
Mr. Sandy.
Well, first and foremost, we were here 2 weeks ago, and it was understood that Mr. Reed's office was going to be representing Ms. Airhorn. They asked for the 2-week continuance. We agreed. That's today's date. I have not received anything either from Mr. Reed's office. I haven't received any notice of appearance. I haven't received any of these declarations or sealed financial or alternatively sealed medical documents that Ms. Airhorn is speaking of. This case has been sitting on my desk ready to go, and I have not had any contact or communication with Ms. Airhorn outside of the brief request for continuance 2 weeks ago. Again, given the circumstances, she's had ample notice of this. This is a case that's been pending. She's been having the criminal issue since July. She's had adequate time to do something, and she largely has neglected that. Again, time is of the interest of this child. We do believe that adopting what our proposed plan is in the meantime is appropriate to get this child back on track. And again, appoint the GAL to see what the magnitude of Ms. Airhorn's problems are. And I think that's certainly reasonable given where we're at in this case right now. So we are asking you to proceed today. She's had time. She's had the opportunity to contact me and has neglected to do any of that.
So, Ms. Airhorn, in regard to continuance, you've had one continuance already. Nothing that didn't, you've filed your responses. You have witnesses that have filed statements. I've read all that. We are going to go forward today. I've got great concerns of what's going on. So anything that you want to, like I said, I did review your statements and the statements of your witnesses. So is there anything else that you wanted to add?
I just wanted to add that Declan is completely safe. I have my own home. I am not residing with anyone. I do not have a relationship with anyone. It's just me and my son. Which is why I was okay with proceeding with the guardian ad litem, because I think there is something she needs to look out for when Declan goes to his dad's, because he is afraid to go up there. Danny has had supervised visitation this whole time and refuses to do it, and I don't know why. He has not reached out to even see Declan, and almost this weekend would be a whole month.
Well, again, I'm just going to object to anything that was not provided to my office or isn't contained in the pleadings.
I can determine that. Go ahead, Ms. Airhorn. Anything further?
Like I said, I got served late. I had a couple days to get an attorney. There was a misunderstanding between me and Mr. Reed, so I was just hoping to get a little more time on this. I work full time, so it's hard for me to take time off to get Declan to school and stuff. So,
All right. All right, Mr. Zandy, anything further?
No, Your Honor, I'll rest on the pleadings.
Okay. So I did review the files and record and everything that had been filed on, and there are some definite mixed concerns in regard to this case, and significant concerns for safety of the child, in particular in the mother's care with the incidents that have occurred. The court also has concerns with the father, but it does appear that he is addressing the issues he has had in the past and in a positive way. The other concern is the limits on which the father has been involved in the child's life until most recently, it appears. And the question is, though, what is the overall, the safest for the child? What's in the best interest of this child? And that's where it's challenging, because the court believes that when mom is sober and not involved in the incidents that she's been involved in, that she's doing a good job. So, so the question at this time is what to do. Mr. Zandy, can you remind me what visitation schedule the dad has at this point?
Well, it's kind of hit and miss. My client came to me back in the summer. It was August, and there was no set schedule. It was basically child was being exchanged every couple of days. My client indicated that was pretty close to joint. It had been that way since my understanding about early July. And then I believe in October, mom changed course and said, well, you can have Wednesday to Sunday every other weekend. And then I think around the holiday season, she pulled back on that. And I think now it's just kind of subject to her whims. So it's been moving target since July.
Okay. And Ms. Earhorn, remind me where the child is attending school. You sounded like you had to take him to daycare or school. Or something.
Yes, he goes to Polly's preschool right now, but he is enrolled in kindergarten at Columbia Heights Elementary starting this fall.
Okay. All right. All right. So here's what I'm going to do for now. One, it sounds like dad has not had regular contact, and I'm not faulting dad. I don't know, there's not a parenting plan in place. And so to do an extreme change at this time, the court doesn't necessarily find as appropriate. At the same time, the court has significant concerns for the child. So here's what the court's going to do. We're going to do for the time, the next, let's see, we're in April, May. For the months of April and May, the time is going to be from the Wednesday to Sunday, every other week. And in the off week, going to have Wednesday overnight. And that's going to continue from April and May, so to the end of May. And then come the summertime, it's going to be alternating weeks. So the child is with each parent 7 days, commencing on Sunday at 5 p.m. The exchanges will be at the Castle Rock Police Department. Only licensed and insured drivers should transport the child. Age-appropriate safety restraints shall be used at all times. Neither parent shall consume any alcohol or mind-altering substance during or 8 hours prior to any visit with the child. Either party may request and prepay the other submit to a 16-test hair follicle or UA at any time they believe the provision may, may be violated. The requested parties shall report to the testing facility within 4 hours of said request, provided he or she is not working, at which time they shall report immediately upon being available. If the test comes back positive, then visitation shall be reviewed upon motion of either party. The results of the test shall be released to the other party of his or her attorney and filed with the court. I am reserving on 191 factors at this time. The mother shall submit to a substance abuse evaluation with input from the father and the guardian ad litem. All criminal records since 2020 shall be made available to the testing facility. Any recommended treatment shall be applied with, and treatment records, including compliance reports, shall be forwarded to the father on a monthly basis. As to a guardian ad litem will be appointed. And if Ms. Turnbull is available, she will be reappointed since she's been involved before. And that will be at the rate of 50-50 private pay. A review shall be set for 2 months from the date of today to provide additional input on the parenting plan. Any prior parenting plan orders not inconsistent with this remain as currently ordered.
And you want to review child support as pursuant to my suggestion in 2 or 3 weeks when we come back for presentation?
So I'll go ahead and allow this on for presentation on April 23.
And I don't know if Ms. Earhart provided any updated wage information, but I would ask that she do that and give my office a copy of a pay stub or a tax return or anything so we can discern what she's earning by the end of this week.
So we have the state, Ms. Looney is involved for the state, correct?
Correct.
So Ms. Earhorn, you should provide that to the state just so they have your current information. Do you know where they're at?
No, I do not.
Mr. Zandy, do you have their address or phone number by chance? I don't have it available in front of me.
I could get it very shortly and forward that to Ms. Earhorn in an email if she prefers, or she can call my office and I can provide that.
I have it.
Oh, clerk has it here.
1338 commas.
1338. So Ms. Earhorn, if you would provide your financial information to Ms. Looney. And then a copy should always go to the other party, or Mr. Zandy.
Yes, ma'am.
Okay, and Mr. Zandy, I would ask you to do the same for your client.
We will update what we have, yes.
Okay.
And Your Honor, this is Amy Turnbull, the GAL, and I would be happy to be reappointed on this matter.
Okay. All right. All right.
Very well. Thank you.
All right. That's it for today. Ms. Cotto, you stated that you have an objection.
I do. What happened is Mr. Anagnostos' response contains significant amount of law that was not previously cited in his previous materials to the court. I would ask one of two things. Just if the court is going to, I would ask the court to not even consider this information because this was not contained in the original pleadings. Original pleadings are, here's my motion, and then I did my response, and then he's got all this law that was not previously cited to that I don't get a chance to respond to. So if the court is going to consider it, then this portion should be put over because I should have an adequate time to provide my own response. The response is to be just what was contained in my information, not brand new materials. And he's presented me with brand new materials that I haven't had a chance to review or haven't had a chance to respond to.
So let me, Mr. Anagnostos, I'll let you respond here in a minute. Here's where I'm at on the UCCJA matter. Well, let me go back for a minute. From what I can tell, is I believe at least a hearing has to occur. That's what I'm looking at. Whether Idaho would want jurisdiction or not at this point, I don't know without a hearing. But there's some unique factors in this case that I'm not sure it's all that clear. And at the very least, I would like to know, because I didn't have a lot of chance, quite frankly, similar to what Ms. Cota has said, to really look in and research the issue of, at this point, I'm thinking I probably have to have one just because it's the home state of the child. But like I said, there's some unique circumstances in this case that applied that I wasn't real sure about. So that kind of goes to what Ms. Cotto is talking about, because I think the series of dates of what's happened in this case make it unique, plus what's in the parenting plan that was filed in the current parenting plan. So that's where I'm at this point, is that I really do want some research. I received what Mr. Anagnostou stated, but I also wanted to hear more from Ms. Cotto, which I think that's probably why I haven't seen anything, is just what she's talking about.
One of the things, I mean, I think I did not respond to all of the information that Mr. Anagnostou cited to in his new information as far as the briefing on the UCCJEA, and he didn't really address my adequate cause, which was appeared to be the second part of the first part of the particular motion. I did address that in my materials. I don't believe that was even cited to. I think Mr. Anagnostou appears to be just addressing the UCCJEA. This is also on for presentation of the special master order too, but.
Right. There are a couple, three different things. So, so let me come back to that in a minute. That's kind of where I'm at with that particular issue on the UCCJEA. Is I think I have to have that hearing with the court of Idaho, and I wasn't quite sure what even court it was.
Looks like.
Yeah, the court is listed in my my documents, Your Honor. If I can respond, though, I'd like to be able to respond to Ms.
Yeah, certainly. I just want to let both of you know kind of where I'm at, because I was trying to sort through everything yesterday. But Mr. Anagnostou, go ahead.
So we start from the position that Washington is not Cash's home state. Cash's home state is Idaho. And from there, Idaho has jurisdiction. So that was my original brief, is to point out to the court that we don't have jurisdiction in this state. Cash's home state is Idaho. Nobody has objected to that. Ms. Cotto, in her response, indicates, well, we have an agreement that Washington, we have a court order and an agreement. And my reply was purely a reply to that point. And I brought up the case law, the Huff case that dealt with that. Yeah, it wasn't brought up in my original brief because you don't bring it up until it's raised in their response, and it's my reply. And the law is the law. Ms. Cotto is saying that Washington has retained jurisdiction. We can't. It's under the UCCJEA. 47 states and the federal government says these are going to be the rules how we decide this. Otherwise, there's going to be improper forum shopping, which is exactly what they say in their declaration. Well, the discovery rules are different in Idaho, so we should be here in Washington. Well, that's exactly improper. That's why we don't do this. We have 47 states and the federal government saying this is how we're going to determine where cases are with regards to children, because prior to this, it was a god-awful mess, forum shopping and people filing all over the place. The court wanted we wanted to make some sense out of all this and make rules, and these are the rules. Nobody disagrees that the home state is Idaho. That's Cash's home state. And from there, under the Exclusive Continuing Jurisdiction Act or provision RCW 2627-211, We don't have, you don't have to have a conversation with Idaho. Idaho has a case pending. They're the state that has jurisdiction. This court, as was done in the Huff case, just summarily dismissed. We're not the home state. Another state is the home state. We're going to dismiss. And in the Huff case, when they dismissed, there wasn't a pending action in Montana. We have a pending action in Idaho. This court just needs to dismiss this action as no jurisdiction. We don't have jurisdiction. If you want to go back to the inconvenient forum and have the conversation with Idaho, you could do that, but there's really no reason. There's no legal authority for doing that. But you know, the statute does allow for the courts to have a conversation about this. But I think the conversation is this correct? This is Cash's home state, and if it is, Idaho should go forward with their action.
Your Honor, if I
Go
might
ahead.
respond. Well, first
Go
of
ahead.
all, Mr. Anagnosto completely misrepresents what has occurred in this particular case. There's a court order that says that Washington maintains jurisdiction. I provided that to the court so that the court wouldn't have to dig for it. We never said there was an agreement. There is a court order that says Washington will maintain jurisdiction unless mother moves to a state other than Washington. At the time, she was in Idaho. So Washington maintained jurisdiction. So it sounds like Mr. Anagnosto is asking to argue the dismissal today. And we would submit to the court, A, that under the UCCJEA, it does, when there's a pending action, there's a pending action here. There's been a pending action for some time. Adequate cause was established. So the outright dismissal should be denied because we have this whole litany, which I supplied the court with not only the dates of what happened, the copies of the orders, and the case law. And Mr. Anagnosto misstates that final parenting plan. My client was not in Arizona; he was in North Carolina. And it says if she goes anywhere except Washington, then the UCCJEA applies. And at that time, she was in Idaho. So clearly, Washington was maintaining jurisdiction. So when we're talking rough, that's part of the issue. Is I'm not prepared to respond to rough because from my brief reading, rough, I should be able to argue against that in the respect that rough was completed. There was no longer anything pending. But again, I got this, and I don't have anything in writing to submit to the court. Now, there was not an agreement to jurisdiction. I never argued that. I don't know where Mr. Anagnosto comes with that information, but the court ordered that, and this has been ongoing for months. Ms. Hoffman never informed the Idaho court. If you look at her materials, she never informed the Idaho court that there's this pending action. It is not just an inquiry. We have had numerous hearings. We have been before the court a number of times. The court did find adequate cause and never did a reversal of the adequate cause. So we're properly before this court, and there's an open pending court. And even if the court says, yes, I have to do the UCCJEA, Ms. Hoffman didn't inform the court that there was this pending open action. So that is crucial, and that's important in this case because the UCCJEA, which all of the states, both Idaho and Washington are signers, refer to open and ongoing. This is an ongoing case, and it's been pending for 4 years. So even if the court says I have to do the UCCJEA, we're still properly before the Washington court. There should not be a dismissal. When you look back at the history, you'll see just hearing after hearing after hearing, and Ms. Hoffman was represented by an attorney. Mr. Anagnosto came on board last March, and he participated in several of the hearings. He participated in this motion to adjust child support. So he's been a participant. Ms. Hoffman was not pro se. So we're still properly before Washington court. Even if the court says I have to have the conversation, that is different than the motion to dismiss. So I think that the court should not be dismissing that if that's what Mr. Anagnosto is requesting. And I can respond to a lot of the information, but I should be able to do so in writing because Mr. Anagnosto goes into the relocation statute and how there has to be a filing of 30 days. There was never a filing that she said she was going to maintain her location in Idaho. So there's a complete misstatement in regards to the facts of this particular case. I have been involved in this case from the get-go, from the original dissolution. So I would submit that the court should not dismiss it. Very clearly, there was adequate cause found. It was never reversed. What the court ruled was that there was not a basis at this time to change custody. And that was what was being requested at that particular hearing. Now, if the court has question as to adequate cause, one of the things that I've requested in my materials was asking, then have Judge Fassett go through and review this and submit a ruling. But there was no reversal of adequate cause. They didn't change custody at the time. What they did is they returned the children back to Ms. Hoffman, and then they appointed a GAL. Well, if there was no adequate cause or reversed it, there would have been no appointment of GAL. That makes absolutely no sense. So we are properly before the court. The court should not dismiss this. I understand if the court says, yes, we have to have the UCCJEA conference, but I haven't had time to brief Mr. Anagnostu's late information, which should have been included in his original materials. Does the court want to hear about the special master order too?
In just a minute. Let's finish this up first.
That's all I have. Thank you, Your Honor.
Mr. Anagnostu, anything further?
Yes, just briefly, Your Honor, because counsel continues to indicate that there's a court order. There is no court order saying that Washington is going to retain jurisdiction. What I point out to the court in my reply is that paragraph 13, the relocation provision of the parenting plan says that if my client moves back to Washington, she doesn't have to give notice of that move. That's all it says. It doesn't say anything else about, Washington taking jurisdiction away from every other state if she lives in any. I mean, it just, that's all it says. She doesn't have to file a relocation motion to move back to Washington. That's not a retention of jurisdiction, nor would the court. The court doesn't have authority to retain jurisdiction under the UCCJEA. It's a federal and state compromise where we're going to determine the visitation based on where the child lives, and the child lives in Idaho. Everybody consents that he lives in Idaho, and the rough case. They went through trial. They went through motions. The parties even agreed.
Your Honor, I'm going to be objecting to Mr. Anagnostu arguing rough, as I've not had a chance to respond to that.
Hold on, just let me hear what he has to say.
Well, it's in response to their position that this course retain jurisdiction. It has not. And when you look at the exclusive continuing jurisdiction statute, we don't have exclusive continuing jurisdiction. Everything points towards dismissing this action, which is what they did in the rough case. But if Your Honor wants to have a conversation with the court in Idaho, I guess we can do that. But it's a summarily should be dismissed at this point, and I think the legal authority points towards that.
So, Ms. Cotto, you can research it if you want. Reality is, I don't agree with what Mr. Anagnostu is proposing. And the court is not going to be dismissing this case. It's been pending for a long time. This matter is being brought up right when, the issues are being disputed. And so bottom line is, under the UCCJEA, there are 2 pending actions, and the courts have to communicate as to which is the appropriate jurisdiction for this matter to proceed. And so that's what's going to happen. I am going to have a UCCJEA hearing with a judge in Idaho. And so that's what needs to occur, because yes, at this point, because the child has resided in Idaho for more than 6 months, then that becomes the child's home state. But that is not an automatic dismissal on what's going on here in Washington. So with that, I will be having my judicial assistant, Autumn Terry, working on setting that up. It will be a hearing, so you will be advised as to when that hearing is going to get set. I'm sure she'll reach out and try to work with your schedules as well. So that's what's going to happen in regard to that part of it. In regard to the question of adequate cause, it's very clear. Judge Fassett did a written ruling that she found adequate cause. So that was on May 22nd, 2020. And then on July 29, 2020, Judge Bassett denied the request for reconsideration. So their adequate cause was found. So I'm not sure why that's even an issue. So with that, again, the court does find it necessary to have that hearing, and we'll get that set up. Now let's go back to the proposed order on hearing of March 12. That order appears to be appropriate. Mr. Anagnostou, again, understanding may not agree with it, but any objections to that form of order?
At this point, Your Honor, we're requesting that there be a stay of those issues, including in particular discovery issues, while the court conducts this the conference with the Idaho court.
So, Ms. Cotto, anything?
I'd object. It would just be another delay tactic. I mean, we could still proceed somewhat, even if the Idaho court decides that, or this court decides that jurisdiction is changed. Given the facts of this particular case, I think it's unlikely given where we're at. I've been involved with UCCJEA, so I would ask that we get going on the special master. The court can have that conversation. I know the UCCJEA conferences are held pretty quickly, so I just hate to delay this any further. I did not fill in the blanks for the, I did file with the income for Ms. Hoffman because all I had was last year's. I didn't have a W-2, so I sent those to the court.
So in regard to the idea of this day, one, this is an order from March 12, so it was ordered prior to any request for the UCCJEA. So my question again, Mr. Anagnostou, do you agree to the form of the order?
I respectfully reject the order based on the court not having jurisdiction.
I'll put refuse to sign.
The court indicated in your ruling, Your Honor, that you were going to fill in the amounts of the percentages the parties are going to pay according to the income information. I supplied, Miss Hoffman had a wage stub back from, I guess, last summer that I submitted to the court along with the information. I believe I submitted child support worksheets showing based on those numbers, the percentages.
Yeah, and I came up with 50-50.
The court had said, though, just respectfully, so the court indicated that given the differences in income, Ms. Hoffman makes significantly more money than my client. Last year alone she was at $58,000 as of June, and my client makes about $36,000 for the whole year.
But that's just for his job. That doesn't include his retirement too.
He doesn't work. He's just on retirement. That's his entire income.
Then I misunderstood what that was.
If the court wants, I can review and resubmit the income information, but I think it was, the court will give me a second. I think it's in my other file. If the court will just give me a second, I will look, because it's not in the, I don't believe it was filed. I thought it was like a 30/70 is what I came up with, but.
So I show the mother's income at about $5,920, and I believe the father's is around $3,000.
Well, and what I've submitted to the court was because Mr. Anagnostou has not provided any current income information, I submitted the income tax. I submitted her W-2 back from when she filed her request to modify the child support, and that showed as of halfway through the year she would make about $90,000, which comes out significantly more than $5,000 a month.
I had $6,000 net for her,
and I think his is about 2,600.
I had 2,933.
That sounds about right.
Mr. Anagnostou, anything?
Nothing.
So that would be 3070.
And I talked to the special master who indicated that she would be charging, I think she said $3,500 for an advance fee.
Oh.
But I'll confirm that with Ms. Bliss.
All right, so I need to address the issue of a stay as well. I just wanted to get these orders entered.
Could I respond? Because this is the first time
Just
hearing.
a minute, just a minute. Let me get this. All right, so I've got those orders entered. I put 3070 for 70% for the
Mother.
and 30% for the father. And then I put refuse to sign for Mr. Agnostu. So then Mr. Agnostu has also requested a stay pending the UCCJA hearing. So Ms. Cotto?
Well, first of all, I'm going to object. This matter has just been pending for a long, long time. My concern is we just keep putting this out and putting this out. We have a hearing date. We've set a trial date for the week of July 16. So we need to really get this resolved as soon as possible. Given how long this has been ongoing, I'd be surprised if Idaho says they're going to take it at this point, especially after the court's talk. But I would ask the court to deny the request for stay.
Mr. Agnostu, anything further?
Well, only that it was in my original motion. It's part of the motion asking for a stay. And the UCCJA provides for that while the court conducts this. And as you indicated, it probably shouldn't be a very long time. I assume hopefully within this month that the court have a conversation with the Idaho court and resolve that issue. And then we can come back and go forward with this action if that is in fact, what happens, which my position is that Idaho has jurisdiction and the case would be transferred there.
Your Honor, I've been waiting since October for this information. This is just another delay.
And I understand that, and that may be the case. At the same time, the UCCJA request has to take priority. So I am staying matters until we have the hearing. And so I've signed the orders to get them signed and get them in the file. But as far as proceeding on anything at this time, we do need to stay everything pending the hearing with the judge from Idaho. So with that,
I have submitted an order, Your Honor, and it allows you to check a box and check the box that the first box indicates that you're dismissing the case. The second one is that you're staying the case until the conference with the Idaho court. I think you could.
when did you submit that? Because I don't seem to have anything.
I thought I submitted it with my original motion.
Then it may have gotten filed as the problem.
Oh, okay.
Your Honor, my only concern then is I don't want to, I understand the court's ruling that they're going to stay the order, but if my concern is that there'll be this ongoing request to keep continuing the matter because of schedules, when I would ask that the court get a UCCJA as soon as possible in regards to the judges. They don't allow attorneys to argue those. Those are done with just the judges. And so, I understand the courts will take the attorney's schedules into consideration, but I would ask the court, and my concern is, okay, we get to delay this until mid-May or mid-June, and then it stays here, then I'm back in the same boat I was in 6 months ago.
It's going to get set. So bottom line, and I'll address that at the time.
Okay.
So I would, in response, Your Honor, I'd ask the court to review RCW 26.27.101, which is communication between the courts, and it allows for participation of the parties.
It does allow, under our rules, it does allow for something to be said by the attorneys.
And I understand that, but my concern is that there will be an intentional attempt to delay it, keep delaying this.
Well, once we have the hearing, it's going to be the hearing. So, we will be going forward. So it's going to get set. It's going to get put before the Idaho court, and we're not going to be delaying it. for one thing or another. It's not going to work.
Okay,
So,
understand.
But,
all right.
yeah.
But no, I'm aware of that, Mr. Anagnostic.
Well, yeah, we want this decided as soon as possible as well, so, you know.
All right. So, Mr. Anagnostic, can you get me an order and get it to Ms. Cotto to just sign off again as to form that I'm staying the matter?
I can.
And I would ask then that Mr. Anagnos include the court's ruling on the non-dismissal, because this is his motion.
Well,
I denied the dismissal. But granted the stay.
Right.
Pending a UCCJA hearing.
Correct.
Okay.
Okay. Thank you.
Thank
Thanks,
you.
Ron.
That concludes this docket. Anyone on here that thinks they had something else? Okay, that concludes the docket.